Negotiable Instruments class, I have made 3 case digests regarding Warehouse Receipt Law or the Republic Act 2137. The second case is Philippine National Bank versus Honorable Presiding Judge Benito Jr. This case is a petition which seeks to annul the resolution of Respondent Judge Benito Jr. declaring the validity of warehouseman's lien. Here is the facts of the case. In accordance with Act No. 2137, the Warehouse Receipts Law, Noah's Ark Sugar Refinery issued on several dates 5 warehouse receipts or cadence. They were endorsed and negotiated to Ramos and Zuleta, who failed to pay their loans upon maturity on January 9, 1990. Consequently, on March 16, 1990, the Philippine National Bank wrote to Noah's Ark Sugar Refinery demanding delivery of the sugar stocks covered by the cadence endorsed to it by Zuleta and Ramos. Noah's Ark Sugar Refinery refused to comply with this demand, alleging ownership thereof. Hence, a verified complaint for specific performance with damages, an application for writ of attachment against Noah's Ark Sugar Refinery was filed. And Respondent Judge Benito Jr. denied the application for preliminary attachment. There are 2 issues in this case. The first is whether or not the unconditional presentment of the receipts for payment carried with it the admissions to the existence and validity of the terms, conditions, and stipulations written on the face of the warehouse receipts, including the unqualified recognition of the payment of warehouseman's lien for storage fees and preservation expenses. And second, whether or not warehouseman's lien is possessory in nature. And here is the ruling of the case. For the first issue, yes, the unconditional presentment of the receipts for payment carried with it the admissions to the existence and validity of the terms, conditions, and stipulations written on the face of the warehouse receipts, including the unqualified recognition of the payment of warehouseman's lien for storage fees and preservation expenses. PNB is inestoppel in disclaiming liability for the payment of storage fees due the private respondents as warehouseman, while claiming to be entitled to the sugar stocks covered by the subject warehouse receipts, on the basis of which it anchors its claim for payment or delivery of the sugar stocks. The unconditional presentment of the receipts by the PNB for payments against private respondents on the strength of the provision of the Warehouse Receipts Law carried with it the admission of the existence and validity of the terms, conditions, and stipulations written on the face of the warehouse receipts, including the unqualified recognition of the payment of warehouseman's lien for storage fees and preservation expenses. PNB may not now retrieve the sugar stocks without paying the lien due private respondents as warehouseman. For the second issue, yes, the warehouseman's lien is possessory in nature. While the PNB is entitled to the stocks of sugar as the endorsee of the cadence, delivery to it shall be effected only upon payment of the storage fees. Imperative is the right of a warehouseman to demand payment of his lien at this juncture, because in accordance with Section 29 of the Warehouse Receipts Law, the warehouseman loses his lien upon goods by surrendering possession thereof. In other words, the lien is possessory in nature. The private respondent's inherent right as warehouseman to collect storage fees and preservation expenses as stipulated on the face of each of the warehouse receipts and as provided for in the Warehouse Receipts Law was not foreclosed. Wherefore, the petition should be as it is, hereby dismissed for lack of merit. The questioned orders issued by public respondent judge are affirmed.